Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On May 21st, 2025, Judge Stephen J. Hippler, who is presiding over this capital case, styled as State of Idaho versus Brian C. Kohberger, conducted a closed, sealed session, which is what the minutes that are sealed from the public describe the proceeding that happened on May 21st, 2025. Prior to that time, a hearing notice was disseminated informing the public that a 10 a.m. virtual closed and sealed to the public hearing had been scheduled with the purpose of the court conducting a proceeding such as this being discussion regarding role of victims. Nothing further appears on either the case summary page or in the hearing notice specifying why would a discussion be needed regarding role of victims. Unfortunately, because the minutes of this closed session are sealed, the public will not, until or unless Judge Hippler orders these minutes to be unsealed, learn anything further on the matter. Notably, when this notice of hearing was disseminated, in addition to the attorneys for both sides being served with a copy of that notice of hearing, another party, a private attorney, was served with a copy of the same, suggesting that he was invited to participate in this discussion, this session that was closed and sealed to the public, and his name is Shannon Gray. Mr. Gray does not represent the state. Mr. Gray does not represent the defense. Mr. Gray represents a victim's family members. This is not the first time that he has been invited in to address the court in a closed, sealed to the public session, because back on January 13th, 2023, at the very start of the proceeding, Judge Megan E. Marshall called an off-the-record, as it's described, closed proceeding to the public in which Mr. Gray was invited and other private attorneys for witnesses were also there, but neither the witnesses' names or the attorneys' names were given. And it appears from the minutes that were disseminated from that proceeding that Judge Marshall at one point appeared to have had to intercede between either an argument that was already in progress or threatened to break out by virtue of what these minutes tell us. These are the official minutes from that closed proceeding. So the question is, if there is a precedent on the record that minutes from closed proceedings where private attorneys have met with the court in Idaho versus Kohberger, including Mr. Gray, these minutes were previously disseminated, why are the minutes from the May 21st hearing, or session, as it's called, closed and sealed from the public? This is an opinion that I provide pursuant to the First Amendment of the United States Constitution. If you have any comments, any feedback, please leave it here. And if you like our content, please hit the like button. And if you have not already subscribed to the channel, please consider doing so, as you will be notified as new content becomes available. Until next time, my name's Kathy. Thank you for joining us today.